Good morning, and let me just share that it is one of my distinct pleasures working here in this context that we can enjoy the interaction with scholars in other academic disciplines and or practical clinical experience who have a keen interest in ethics. We might work in some place that does nothing but read and talk about very old scholars who talked about and read about ethics. But we live in a place where it's very interactive, very interdisciplinary. And one of our colleagues that we enjoy involving in conversation is Dr. Donna Carlson. She'll be our speaker this morning. Dr. Carlson comes to us with a number of academic degrees, including a bachelor's degree from La Sierra University, and then a master's of public health from University of California at Berkeley. She received her medical doctorate degree right here at Loma Linda, and then went on later to the University of Southern California, that's USC, the law school there, and graduated there in the Order of the Coif, the Order of the Coif, which means she was in the top 10% of her graduating class. Those of us who are not JDs have no idea what the Order of the Coif is, but it sounds, okay. A coiffeur is a hairdo, so yeah. Well, anyway, Dr. Carlson is a member of the California State Bar Committee on Professional Responsibility and Conduct. She is a member of the Medical Legal Committee of the San Bernardino County Medical Society, and she is a Deputy County Counsel for the County of San Bernardino. Thanks for joining us.
Thank you. Okay. Thank you. Oh.
We can just leave it here if you wish.
Yeah, I probably
But
won't.
then you can't move.
Oh, I can move just a little, right? Okay.
That's fine.
Well, good morning. Good morning. Before I begin, I want to find out something about the audience. I'd like to know a little bit about how many of you are, in one way or another, from the legal community, either attorneys, paralegals, work in a law office. Okay, 4 or 5. Medical community people? Any students here? Students here. Okay, good. Okay. And what kind of students? What area are you from? Masters in bioethics and nursing. Nursing and ethics. Okay. All right. I'm going to talk this morning. I want us to think for a little bit about law as a bridge. Law, a device that connects and separates orders relationships, usually, and we're going to think about it in binary terms, although it sometimes orders more than 1 or 2 relationships. It operates to connect, both connect and to separate. And let me see if I can make this work. And you'll also notice that some things it just goes over. There are things in the darkness under the bridge that haven't been addressed yet by law. I'm going to do a very short introductory section. It'll be basically a review of 8th grade civics. The lawyers, if they want to, can go to sleep. And then we will get into discussing a particular statute, the EMTALA, the Emergency Medical Treatment and Active Labor Act, that some of you may be familiar with, and that has had a lot of effect in the last few years on medical care and I think eventually on emergency preparedness. Okay, law is basically, and this is a simple definition, as I said, the lawyers can go to sleep, it's a set of rules to encourage certain kinds of behavior and to discourage other kinds, and it needs to be distinguished from social convention. You see the sticks and the carrots, that's basically the enforcement mechanism for law. And if you think about how something becomes a law, you will recognize to some extent that some of it is social convention that people have stopped following. And I like to use the post office example. The convention is that we go in the post office, we stand in line. If people started cutting line, they'd probably put up a little sign that would say, please stand in line. If people persisted in doing that, some rebellious sorts, they would put, $25 fine if you don't stand in line. And if it still persisted and society considered standing in line very, very important, they would perhaps put up they maybe station a policeman there, and if you cut in line, they'll arrest you. And finally, they may start hanging people in the parking lot. That would, of course, be, if anybody came to the post office at all after that, it would certainly be a sign that this is a very important social value, standing in line. So when we look at a law, you ask yourself, what are they trying to make me do or not do? And how are they trying to make me do it or not do it? And look at the size of the penalty. It'll tell you something about the importance of the idea of right and wrong underlying that particular line, that particular law. The foundation of law is ideas of right and wrong. People call it values, but I don't like that term. It's a little slippery, it's very manipulable, and can't always put your finger on it. People can turn it around and make it mean a lot of different things. Basically, it means ideas of right and wrong that are embedded in the culture or the society in which the law is found. And you see here I have, those are supposed to be the Ten Commandments because they underlie. Now, what is the most fundamental value of this society, do you think, of American society? Anybody? Freedom, right. George just told us that not very long ago. Yeah, I called it autonomy. But basically, yeah, individual freedom. That's our base. And everything that comes in, every law that comes in some way infringes on that base. We have some other values. You see the Constitution there. Equality, fairness, and economy is one, or efficiency is one that's getting more and more attention. Let's see, I gotta follow my own notes here. This is not a very jazzy slide, but I wanted to make the things, come popping up, but I'm not swift enough with PowerPoint to do that yet. But it's basically designed to show you that values reorder over time and under different circumstances. So if you look at the top line there, I have autonomy first, then equality, fairness, and finally economy. What time period do you think that represents? Anybody? Early, exactly, very early. When they're writing the Constitution, 1787, they're saying autonomy is extremely important. And they express autonomy as property rights, basically. Then a little time goes by and autonomy moves down the line a little bit. What time do you think we're talking about now? Civil War, right, because they say, you got your autonomy, you got your property rights, but we're going to intrude on this. We're going to not let you be as autonomous as you would like. A lot of blood shed over that. Okay, we get a little further down. Fairness starts coming in. And we're civil rights, precisely. I had it, you answered just like my husband did when I ran this by him. I said, well, what about the period of suffrage, the 20s? Because the Civil War, of course, gave equality and the vote only to black men, not black women, not white women. It took us, quite a few years. And the New Deal, that's another time, exactly, when fairness starts coming up to the front. But we're moving, oh, wait a minute. Okay, to the bottom there, where we got economy at the top. Present day, because, why? Scarce resources. And it starts becoming more and more important to economize. What do you think the ultimate economy is? What would you say the ultimate economy in the healthcare system, for instance? Let the patient die, right? Because if a dead patient doesn't use up much in the way of resources, or a dead person. Okay. Law usually follows this reordering of values. This is a very famous quote from a very famous case. This is Trope v. Dulles. Somebody's suing John Foster Dulles. Remember, he was Secretary of State for a while back in the 50s. And one of the Supreme Court justices, Earl Warren, actually, in the majority opinion, used this phrase, and it's been quoted many times in other cases. Trope v. Dulles was a case. Trope was a young man who, in 1944, deserted from the Army, and he was brought before a court-martial, and the military tribunal did what military tribunals could do in those days, relying on a law that was left over from the Civil War. And it said that a deserter could be deprived of citizenship and given a dishonorable discharge. So that's what they did to him. It gave him some hard labor time too. And then a few years later, Trope, not unreasonably, wanted to leave the country. And he went to try to get a passport. And what he found was that he didn't have citizenship. He couldn't get a passport. He was a man without a country. And that became a case that worked its way up to the US Supreme Court. And the Supreme Court said, can't do this. This is an old law. This is a different time. This is not the Civil War. A military tribunal, for sure, if anybody could deprive somebody of citizenship, it can't be them, or it can't be they. And we're not going to allow this to happen. So they restored his citizenship. And that's where the phrase came. This, Earl Warren said, marks the evolving standards of decency, that mark the progress of a maturing society. We are evolving, we are changing, we are getting better. Anybody wonder why that law was considered okay at the time of the Civil War? What would have been the purpose of it then, depriving somebody of citizenship? Who was fighting whom? Right. So this was a law from the North, because they didn't want, what happens to you if you're a deserter? Well, besides getting shot, little things like that. But you also became, in essence, a kind of rebel. You became the enemy. You were part of the other side. So you're not going to be in our group anymore. Okay, what's the impetus for all law? Another famous statement. This comes out of the common law, actually. A mischief to be remedied. Judges, legislatures, these are all the ultimate do-gooders of our society. And they look around for mischiefs to be remedied. How does a mischief to be remedied come to the attention of a court, for instance? Through a case or a controversy, a lawsuit, exactly. And sometimes, depending on the statutes that are available, the court can do something about it, and sometimes they cannot. This is the cycle of the evolution of law, or a law. Again, this is pretty simple stuff, but starting at the top, you see a situation, we have cases, we have controversies. Something happens out there and people get unhappy and they can't agree. Let's go to the court and get a third person to settle this difference for us. And the court says, oh, we wish, and they often say it in cases if you read them, we wish the legislature would do something about this problem. We are only a court. We can only settle this immediate problem. We can't do anything about remedying this mischief society-wide. So they actually will sometimes almost request. And of course, the legislature keeps its eye on what's going on in the courts as well, and they think up some laws to pass. So they pass a statute. And this can be, and this is done, remember, and always remember, at both the federal and the state levels. And this becomes very important because American law is very complex. You always have to make sure that you are doing what the feds want you to do and doing, in this case, what the state of California wants us to do. And the state of California laws can be very onerous and often are more onerous than the federal laws. California always goes a little further in defining rights and making rules. Okay, the legislature makes the statute, they turn it over to an agency. And the agency says, okay, this statute says stand in line at the post office. What does that mean? Okay, we're going to write the regulations. And you walk into the post office, you walk 25 feet in, you turn right, you stand behind this line, and you wait until an agent calls you. And then they send enforcement. They also, the same agency, items 3 and 4 here are agency involvements. They send an agent out to stand in the post office and watch and make sure that this law is being followed by everybody. And then somebody gets somebody doesn't follow it, and the agency issues a citation. It's very much like when the policeman says, you've been parking there too long, here's your ticket. And you say, no, I haven't been parking there too long. I'm going to court to fight the ticket. So you go to fight the ticket, and where do you find yourself? Now, in the case of a parking ticket, it's a little different. But in the case of EMTALA that we're going to get to pretty soon, you find yourself at the agency where an administrative law judge will hear your case. So the agency that has just given you the ticket is now going to, at another level, judge whether or not your ticket was appropriately given. If you don't like what the administrative law judge says, you get to appeal. Guess where you get to appeal? Higher up in the agency, sometimes to the national level. Finally, if you don't like it, and that's what the little agency 2 levels means up there, you go to the regular judicial court system, and you bring your case there. In the case of EMTALA, and many agency situations, like the IRS agents, very same system. They come, they say, you owe $100,000 more, or $5 more, and you say no. And you go through these 2 levels at the IRS, and then finally you get to the courts. But in the case of a federal statute, you do not go to a trial court. You go straight to the Court of Appeals, the circuit court level. So if you don't like what the agency has given you in two shots, you go to the Ninth Circuit, and you say, Ninth Circuit, this is wrong. And the Ninth Circuit will look at your case. But there's some problems with it because the Ninth Circuit is required to give what's called a very deferential standard of review. And you heard Professor Shapiro talking about standards of review yesterday. By deferential, it means they pretty much say, well, the administrative law judge said this, and they know what they're talking about. They know this area better than we do, so we're probably going to affirm. And now we are to EMTALA, the Emergency Medical Treatment and Women in Active Labor Act. That's the original title. They dropped the women in because it doesn't make a nice acronym, and also because I think, did you ever see men in active labor? Do you ever see men laboring very much at all, actually? No, that's a cheap shot. It was passed as part of COBRA in 1986. I imagine because I'm here, everybody knows what COBRA is. Anybody? COBRA. Somebody? What is? Yeah, it does include things about medical, but you know what the acronym is? COBRA. No. Mitch, you know. No. Okay, it's all right. Don't worry. I didn't know either until I went. It's the Consolidated Omnibus Budget Reconciliation Act. It's this big. It's a serpent, really, with fangs. It has a lot. It covers, the waterfront, but it tells you something. Oh, you don't want to write this down. Okay, Consolidated Omnibus. See, I can't even say it. Budget Reconciliation Act. COBRA, and you'll find your retirement benefits in there, and you find all sorts of subdivisions. And EMTALA was added almost as a footnote, a little bit of an afterthought, and wasn't given a whole lot of debate and not a whole lot of chance for discussion when it was tucked in there. But it has had a big effect on the practice of medicine and the practice of law. I'm sorry that Marianne Hyde is not here today because she was an attorney in attendance yesterday, works for Tenet Medical Systems, and deals with EMTALA every day. And she and I were talking. She says, I wondered if they're going to say anything about that because it's a big axe that lies over or hangs over this profession. Okay, how did EMTALA get started? A little bit of the history. Somebody had to identify the mischief to be remedied. Well, there were some cases out there. People getting turned away from emergency rooms. Women coming to an ER in labor, and they'd say, where's your insurance card? You don't have one, or you have a Medicaid insurance card. Your hospital, the public hospital, come on in. You guys, come on in. It's okay. Sit down. There are plenty of seats.
Feel free to sit on the floor.
Or feel free to come and sit in the chairs, too, if you want to. You don't have to sit on the floor. Anyway, so we got to identify the mischief to be remedied. So, and there's a number of studies that were published. Come on in. A number of studies published about this problem. The poor and the uninsured are being turned away from emergency rooms, and they are being transferred to public hospitals, sometimes in unstable condition. Why do you think this was happening in the 80s? Economy, right, is starting to become the dominant value. What was going on? What had happened before then, and what had changed? DRGs, exactly. And the That's correct. But there was a little slush money in the medical system. And where did it come from? It can't, well, this applies, by the way, to Hilburton. But the slush money on a day-to-day basis came from the insured patients. And it was that enabled the hospitals and the physicians and the medical community to take some of that slush money and use it to cover charitable care. Now, as the HMOs rise, the slush starts getting squeezed out. The hospitals are finding themselves more and more in straight circumstances. They don't have the money anymore to shift from the insured to the uninsured. So they start sending them, well, look, we pay our taxes, the county hospital's over there, let's send them. Well, the legislature decided to remedy this mischief, and so they passed COBRA EMTALA. And I put the citation in there for anybody who has trouble sleeping at night and you need a soporific. Use this, look this up and you can read it. It's not actually, the basic EMTALA is not that long. It's only about, maybe 7 or 8 pages. If you really want to go to sleep, download the regs and the review guidelines. That will do it for sure if the EMTALA doesn't put you to sleep. It basically, although it addressed the issue of patient dumping, it really was a mandated standard of care for hospitals. And the goals: stop this transfer, increase access to medical care for the uninsured, and although that was the unspoken impetus, although nobody said anything about it, was to shift the cost to the private sector. Create some kind of a safety net, some sort of universal health care at a very low and minimalist level, and make sure that it's not the government that pays for it, it's the private sector. Okay, now we're down to the regulation part of this evolutionary cycle. And we have 2 agencies operating here. Remember I said that you have both state and federal regulations going on at the same time, so we have a pretty complex net of law, and it's hard sometimes to sort it all out. But the federal executive agency is, and it's not helped by the similarity in the names, the Department of Health and Human Services, DHHS, and they put out the Code of Federal Regulations. The state executive agency is the Department of Health Services, and they put out the CCR, which is the California Code of Regulations. And again, I'm not going to say too much about it because Bob Ragland will be talking, I think, about health and safety code and then about some of the regs that follow. So just keep in mind that you're under 2 guns at all times. And finally, the agency enforces them. They have agents, and the agents come armed with sticks and carrots, and they're going to enforce this law. How it works. Okay, here's the sticks are over here, and they're pretty big sticks. The sticks are so big. This is kind of maybe just one step below hanging in the parking lot, because civil fines are $25,000 per violation for hospitals that are less than 100 beds, and $50,000 per violation for hospitals that are over 100 beds. What is the importance of the distinction between per violation and per patient? Anybody? What do you think? Why would they set it up this way? Don't tell your husband, tell me. Somebody. Exactly. You could commit several violations on one patient, precise. And that means that you're $50, $100, $200,000 if you violate the provisions by transferring inappropriately, you forget to send the records. I know of one case from this hospital because my sister-in-law works at the ER. They forgot to send the records. We got an EMTALA. You know about the case? It happens many times. So you get the x-rays or some portion of the lab test when you're going to transfer. In the case I know about, they went through all this EMTALA process and found out that the records had been left in the ambulance because the ambulance driver forgot to bring them in. And so there really was no, but it was only after a whole lot of headache and grief. you have civil liability, and this is really the biggest stick of all, because in this law, not only does it give you a variety of things to do, we're going to look at it a little more closely in a minute, it creates what's called a cause of action. And that means that it creates a basis for a lawsuit. So not only does the government come along and say, give me my fine, it says, go ahead and sue. It encourages people to sue the institution. And that's where the big money comes in. Because it doesn't fall under the medical malpractice protections, for instance, here in California. MICRA doesn't cover this. They've created a cause of action that allows people to sue for big money. The other thing they do is they report to other agencies. Now that basically turns into taking these carrots away, turning the carrots and transforming them into sticks. Because when you get an EMTALA violation and the agent comes in, they call the IRS. They say, guess what, IRS? They're doing this, and maybe we ought to look at that tax-exempt status. When they call the accreditation body, JACO, and they say, guess what, we got an EMTALA violation. Maybe you ought to look at the accreditation of this institution, and so forth. And they will say, oh, you participate in Medicare. I think we're going to take you off the list. And all your payments are gone, because lots of patients are covered by Medicare. So these carrots are really double-edged swords. And for a physician, of course, it's a medical license is our carrot. The core provisions, every person coming to an emergency room and asking for help, and this is for medical help, this is every person, must be given a medical screening exam called an MSE, and if an emergency medical condition is diagnosed, the person must be stabilized before transfer or discharge. And if you think about it, discharge is a kind of transfer. It's just transferring you home. And the most important thing is that there may be no transfer at all for financial reasons. Okay. I apologize. This, I think, is the most boring slide in this whole presentation. I mean, you may have a different opinion, but I think it was important to put it in because it defines an emergency medical condition. And it's a long and involved, this is how the government talks. Emergency medical condition means a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, psychiatric disturbances, and/or symptoms of substance abuse, such that the absence of immediate medical attention could reasonably be expected to result in all these terrible things. That psychiatric disturbances and symptoms of substance abuse was put in there to cover whom? Homeless people, and who else? Every drunk driver that the police bring in and say, we need an alcohol test, a blood alcohol test. Everybody who shot up a little too much, and because in the past, these people, well, you know, they brought it on themselves, they're not too bad, ship them out. Hospitals didn't want to deal with them. They were the sinners, the real sinners. But you can't do that anymore. Not only that, psychiatric disturbances. I don't know if there are any psychiatrists here, but they're going to actually have to work. Because, I mean, psychiatrists taking ER call, who ever heard of such a thing? But now, if you have a psychiatrically severely disturbed patient and the ER doc calls, the consultant is supposed to come in. Anyway, anything placing the health of you and any bodily functions or bodily parts that might not work very well because of this. And it's important on respect to, remember a lot of the cases that brought this law up were labor and delivery cases. Pregnant woman who's having contractions. You can't get her to the next place fast enough, or the transfer may pose a threat to her health and safety and that of the unborn child. Some more terms and regulations. The emergency medical condition, this is interesting also, is judged by the prudent layperson standard. So that big long slide that had defined emergency medical condition, that's not defined by the doctor or the nurse or the triage person or anybody there. It's judged by the prudent layperson standard. And how this got in is kind of interesting. It's the state laws, actually about 47, 48 states now that have this. What do you think? Can you think about why this would come? They would feel the need to specify this. Who's going to decide? Anybody? Well, no reason why you should particularly, because the insurance companies, who's coming to the ER now? Not just the uninsured, it's the insured as well, who know that they can run in and get an ER check. You don't have to make an appointment with your doctor, it might take 2 or 3 weeks, go to the ER. But the insurance company said, wait a minute, that's not an emergency medical condition. The final diagnosis was upper respiratory infection. So they were basing their payment on the final diagnosis, not on the presentation. And some of the hospitals said, you know, they were paying $50 for an ER visit, even after all of this work was done, and not paying for it. So the insurance companies, against their will, got dragged kicking and screaming into EMTALA and being forced to pay. The medical screening exam includes specialty consults, and I forgot to put on the slide, it includes labs, x-rays, CT scans. It's not a little screening exam where the doc goes in and says, yeah, you got an ear infection, you know, go home. If there's any question at all, you have to use the full capability of the hospital. Stabilization doesn't mean just stabilize for a little while and then you can send them to county. It means full treatment of the emergency medical condition to the maximum capability of the institution before the patient can be transferred. And women in labor specifically have been stabilized after the infant and the placenta have been delivered. Other things applies to all Medicare hospitals, applies to the sending and the receiving hospitals, and all patients, not just Medicare patients, regardless of the acuity of the presentation. Remember we had that all acute presentations? Well, that's out the window. Just anybody that walks in. Comes to the hospital means you get onto the hospital property, and we'll talk about that in a minute. You can't make any financial inquiries before they start the medical screening exam. And in lots of places, they separate, and it's recommended that the ER doc work blind in terms of knowing anything about the financial state of the patient. So they will take the financial information sheet. If they have anything on it, they just take it off, and the only thing he knows is the presenting complaint, or she knows. You had a question?
I just had a comment that I think it's important to realize that this is an evolutionary thing.
Yes.
In the 80s, when it started out, we didn't have all of these.
That's correct.
They come up as they picked up the deficiencies.
That's exactly right. And you're anticipating my next slide. This is, and the use and exhaust rule, you have to use everything and you have to exhaust all your capabilities. Strict transfer rules, you've got to send them with somebody in the proper equipment, and you can't just put them in an ambulance or a private car. Signs have to be posted everywhere letting the patients know you have a right to a medical screening exam. And they have to be everywhere. And they can't be near a sign that says, please get your insurance card out. They actually physically have to be separated. The signs have to be available in all the languages that you're likely to serve. Then here come the judges. Okay, we got the statute, we got the terms, now we're going to have some cases. Because remember, we get around that circle and somebody doesn't like the law. And one of the first important cases that came out is actually, let me see, I can't remember, I think it was Missouri, or Burdett versus the the Department of Health and Human Services. So what kind of a case is this? Federal case. Remember, the federal agency is DHHS. So a lady comes, this took place in Victoria, Texas. Gravida 6, para 5. 6 children, 6 pregnancies, 5 children. Lady comes in. She presents to the ER in Victoria, Texas. She's in labor, and she has a very high blood pressure, 200 over something. She's had no prenatal care. She has no insurance. Where do you think Victoria, Texas is located? Well, not quite on the border, but not far. The doctor on call, who was the chief of OBGYN, didn't want her. Said, I don't want that patient. He examined her one time, said, yeah, she's got high blood pressure, give her a dose of mag sulfate, and send her out. The nurses argued with him, but you know, she's got this high blood pressure. Not my patient. And the doctor says, and I think this is one of the things that made the court so mad at him, until the hospital pays my malpractice insurance, I will choose the patients I want to treat. What value is he expressing here? Autonomy. But somebody turned him in, and I often wonder if it was the nurse that that he didn't pay any attention to him. Anyway, that he didn't pay any attention to. He sent her away in the ambulance. She delivered a healthy baby on the way. The nurse who was, and the mother did fine and the baby did fine. So there was no bad outcome in this case. But the doctor got fined $25,000, which was the maximum that at that time that they were giving. He didn't, and the court went through all this. He did get to the regular court system and the Circuit Court of Appeals, and it said, and they announced a few, just as you were talking about, some additions and modifications to these rules. It said on-call doctors must see patients when the ER doc calls, and the EMTALA regulations requiring on-call physicians to give care to all patients does not amount to a taking of the physician's services without just compensation. This man, this Dr. Burdett, made a claim under the Constitution, a constitutional claim, said, you are forcing me to see somebody. You are taking my work without compensating me, and you can't do this. It's a violation of the Constitution. The court said, no, you don't have to be on call for this hospital. You don't have to contract with this hospital. Nobody is holding a gun to your head making you do this work. It's one of the conditions of your contract you have to see. And finally, that the violation, the imposition of a violation, will not be judged by the medical outcome. Smith v. Richmond Hospital, this is a Virginia case. Richmond, Richmond Community Hospital this way, or Memorial Hospital, I think. And this is another OB case. This time the lady is admitted to Richmond Hospital, and she's there for 5 days with premature rupture of the membranes. Okay, medical people. What happened to her? She got septic, right, very septic, and needed a C-section post-haste. The doctor who was on call gave a telephone order for her because they didn't have all of the facilities. I think it was an anesthesiologist at Richmond at that time, or available anyway, to do a C-section. So he gave a telephone order for the lady to be transferred to the University of Virginia Hospital, where they had a big NICU and they had lots of doctors and could take care of this lady. But she did very poorly. And the baby was born septic and now has cerebral palsy. The case took place in 1988, just a couple of years after EMTALA, but it didn't come down until 92. So she had insurance. What kind of insurance do you suppose she had? Medicaid. And why do you think, ostensibly this was not a transfer for financial reasons. But they got a septic lady, going to deliver a bad baby, going to be in the in whatever nursery they have for a long time, going to run up a big bill, and Medicaid's not going to pay us very much, especially not in Virginia. Okay. Lopez Soto v. Hawaii. This is a Hawaiian case. Oh, wait a minute, excuse me. No, I'm fooled by the name. This is a Puerto Rican case. This is out of Puerto Rico, 1st District. Lady comes into the hospital. She delivers about 7 hours. Baby had respiratory distress and a pneumothorax. Again, they don't have proper facilities. They called a pediatrician. Pediatrician came in and saw the child, arranged for transfer to the children's hospital, which wasn't that far away. It had an NICU. The baby died, however, over at Children's Hospital on the 2nd day, and the parents sued based on EMTALA. And one of the defenses was, look, this baby didn't come to the emergency room. EMTALA only covers emergency rooms. It says so right here in the statute. It says emergency room. And the court said, come on. The baby arrived in the delivery room, this is where babies arrive. And so they said, covers the whole hospital, not just the emergency room. Am I running out of time? Oh, okay. 10 minutes, okay. Yeah, I want to get, okay, maybe we'll skip this one, contract and fiduciary duties basis for doctors to have to respond. This is a more recent case, and it's an interesting one. This took place, this is Ravenswood Hospital. Anybody know where the Ravenswood is? Chicago. Good section of Chicago, you think? Maybe not. This is a 15-year-old boy who's got shot while playing basketball on a playground at a school near the hospital, and his friends dragged him, carried him toward Ravenswood Hospital. They went, and somebody ran into the ER and said, he's been shot. Please come out and take care of him. The nurse says, sorry, we don't leave the hospital. You've got to bring the patient in. Why did they say that? Because the EMTALA says the patient has to come to the hospital. So if the hospital doesn't go to the patient, if they don't go out and try to take care of him, then they're they think they're out from under EMTALA and EMTALA liability. Well, the police came and they said, please come and take care of him. Nope. So finally the police carried him in. He had a torn aorta. He died, and the hospital, and then the court said, mm-mm. And this was the genesis of what is now called the 250-yard rule, that the hospital is not just the hospital, not just the emergency room. Remember, we got it expanded to the delivery room and then to anywhere in the hospital. Now it's expanded to 250 yards radius from the emergency room and from the hospital campus. So you go all the way out to where the hospital property stops, and then you go 250 yards beyond that. And I don't know what you do at 251 yards, but it's just fair. Anyway, but it has come up as a problem, because if your security guard is walking around the edge of the hospital property and he sees somebody lying in a pool of blood 251 yards away or within 250 yards, then the hospital, at that point, the hospital knows. And when the hospital knows, the duty to take care of that patient arises.
What would have been the downside for the hospital going out and picking up that?
Of course, common sense would have told you, go out and pick them up. But they were concerned about incurring liability if the kid died. Go ahead.
It's not just the hospital liability, it's the licensed people's liability.
That's, yes.
Grant attorney runs out, throws the patient on the gurney.
Yep.
The patient dies or something goes on, the hospital says, I never told you about this.
Yeah, it's a good point.
And there she stands all by herself.
Yep. Okay, so we have formula for disaster, expansive and expanding requirements, no money, unfunded mandate. Results of the cases and the rules, and the cases that added. Well, did the legislature meet its goals? It met some of them. Nobody's turned away from emergency rooms, or almost nobody anymore. The poor and the uninsured are getting some medical care. The cost has been shifted to the private sector. Has it increased access? Has it really? For some people, to some extent. It has some unintended consequences, and I should have had one more bullet in there, because I'll talk about the effect on emergency preparedness. Okay, immediate effects. You got crowded emergency departments. You got increased waiting time. We've got the development now of some community-based MRSAs, because everybody's sitting in there all crowded together waiting for 7 or 8 hours. You got the flu. Guess how many people come in without the flu? They got it when they leave. Increased documentation. Takes lots of time. And I've talked to some ER docs, because I haven't worked in an emergency room for 25 years, and what I remember is different from the way it is now. So I talked to some of my friends. They said they estimate they spend 2 to 3 times as much time writing down what they do as doing what they do to help patients. Because the documentation is so onerous and the penalties are so big, those great big sticks that everybody's worried about, that they have to cover themselves. And they have a whole group of special people that go through everything and make sure that all the documents are right if they have to transfer, or if they, whatever decision. It's got to be available and make sense to these little reviewing officers that come, who often don't have a medical background. Decreased rationality. One of my ER docs says, he says, I'm not a rational being anymore. I know when I examine this patient that they've only got the flu, but I got to worry the 99th of a 99th chance that maybe they have something else. So guess what? Everybody gets a CT of the abdomen if they come in saying my stomach hurts. So the costs are going up, the time goes up, and the efficiency goes down, and you add up all these factors, and what happens? The ERs end up on diversion, so nobody gets any care. They have to go somewhere else. But there's a caveat to that. What happens if every hospital's on diversion? If they're all on diversion, nobody's on diversion. So that's basically, there's a computer that keeps track of all the hospitals in the area, where the beds are, what's available, and it's checked and updated every 2 hours by all our, Loma Linda and Arrowhead and all the other county hospitals, so that they know, and as people go on diversion, and they have specific rules before they're allowed to do that, if everybody's on, then nobody's on. When is this going to become important? Everybody's going to be on diversion when the disaster comes, right? Okay, the other things that are happening, specialists refuse to take ER backup call, or, like my husband, who's an orthopedic surgeon, they count the days. He's waiting for his 65th birthday so that he could go on senior status and he won't have to take ER call. It's liability, doesn't want to do it. And in some places, they're having to pay the specialists now, because they say, you know what, I don't need this hospital. I'm going to not admit patients anymore. I'm going to just do outpatient work, and I'll refer stuff. And they're backing off because the liability is so great. And for the kinds of things that the doctor can't handle and calls the specialist, those are the bad cases. Nobody wants them. Okay, there's also a rise of specialty hospitals. There's one on the drawing board right between actually here and Redlands. And maybe you've read some things about it in the local papers. What does a specialty hospital do? It avoids EMTALA, and how does it do that? That's exactly right. It has no emergency room, doesn't offer any emergency services, doesn't hold itself out to the public as an emergency place, and it doesn't see walk-ins, because another way of defining emergency is if you take 1/3 of your patients or more in the previous year as a walk-in without appointments, then you are an emergency department. And of course, you read this in the paper, closing of emergency rooms in hospitals everywhere, 3 per year in California. And it doesn't take long, and of course LA is really feeling the pinch. Okay. The rural areas also. Patients and doctors start breaking the rules. Doctors admit, because that gets you out from under EMTALA, you hope. And the patients, they get so tired of waiting. There's a phenomenon, it's interesting. They wait a long time and they figure out that people who come in by ambulance get seen first. So we've had patients go home, they call an ambulance, and they get themselves taken back to the hospital, try to jump the queue. What has happened? EMTALA has been amended, or new guidelines or regs have been added in. Look at these years. The underlines are amendments, and the ones that aren't underlined are regs and guideline changes. 94, 97, 98, 99, 2000, 2001, 2003. When a law gets amended that much, what is it telling you? Nah, it's got some problems. Okay. Decreased access to care for everybody, collapsing system, decreased emergency preparedness. I want to get to my real. Okay. How did we get here? Now, everybody has put this up, and I want us to think a minute about reordered values. What has always been the ethic of the medical profession? Compassion, charity, care. How many hospitals around the country are named Good Samaritan? I don't even know if we could count them. And I think all the elements of EMTALA are right there. What did he do? He came, he evaluated. He saw the man had trouble. He realized he needed help, and he had compassion. He stabilized. He irrigated the wounds, poured oil and water and bandaged up. He gave the care. Then he transferred him appropriately on the right kind of transportation, and he went with him himself so that he had an expert riding along. And he took him to an appropriate accepting care facility, the innkeeper. He made arrangements for ongoing care. So this, to me, is the basis of EMTALA. So why did we need a law? Remember I said at the beginning, if there's a law, you always ask yourself, what are they trying to encourage and what are they trying to discourage? And why? They're encouraging Samaritanness, if you will. And is it because we have abandoned our core values and adopted the economic values or allowed them to be superimposed on us? Could the Samaritan have handled 10 or 20 people? So other people have asked that. How could we do something? Can we increase the supply of Samaritans? Can the government be a Samaritan? Can we retrain the priests and the Levites? And who are they anyway? And I get, these are just questions to think about, obviously. Can Samaritanness or Samaritanhood be legislated? Can we have occupational re-education programs for robbers? And any other ideas that might come with? Oh, I said also that law is a bridge between the present and the future. And so I'm going to close with one of my favorite quotes. Most of you will recognize it. It's from Tennyson's Ulysses, and it begins actually with the more famous part of it, which says, I am a part of all that I have met. Perhaps you remember that. Yet all experience is an arch wherethrough gleams that untraveled world, and I put in parentheses, maybe a just society, whose margin fades forever and forever when I move. It's always a moving target. Ideal reality is always ahead of us. Thank you.